Can you be jailed just because you are the director of the company? Imagine you resign from a company and months later you are dragged into a court case for something which happened after you left. This is what exactly happened in S.M.S. Pharmaceutical versus Neeta Bhalla 2007 case, which redefined the liabilities of directors in India. So here's the full story. S.M.S. Pharmaceutical Company had some extra cash. So, like any other company, they decided to lend it for quick returns. They gave 2 crores to direct finance as a 15-day deposit at a massive 25% annual interest. But when S.M.S. Pharmaceutical Company deposited the check, they all pounced. So naturally, they sent a legal notice to them and filed a criminal suit against them. The complaint was filed against managing directors, other directors, and surprisingly, Neeta Bhalla. Here's the twist. Neeta Bhalla claims that she has already resigned the company before these checks were even issued. So here's the big question. Can a director automatically be held liable just because his company dishonored a check under Section 141 Negotiable Instrument Act? Or does the law requires actual proof that they were actually in charge of running of a business? So, the arguments of S.M.S. pharmaceutical companies are that all the requirements of Section 138 are met and all directors, including Neeta Bhalla, is responsible for company's affair. They relied on the fact that board resolution shows that directors were involved in the decision making of the company and argued that a complaint doesn't need to repeat Section 141 word by word, but overall involvement is enough. And on the other hand, Neeta Bhalla argued that the complaint was vague and the company never stated her role in the business on the day-to-day basis. She also states in her argument that she has already resigned from the company way before the checks were even issued and she didn't even receive the notice about it. Furthermore, she also states and claims that just because she was the director of the company doesn't make her criminally liable under Section 141. And the Supreme Court sided with Neeta Bhalla and lays down the principle which still guides the company law today. First is that being a director isn't enough,
since criminal liability needs specific allegation of responsibility.
Complaint must show an active involvement.
Vague statements don't work.
Managing directors and check signatories are presumed liable,
since they run day-to-day affairs.
Strict compliance are essential,
since criminal law cannot rest on assumption.
And finally, resigned director cannot be prosecuted
for acts committed after leaving.
So the court dismissed the case against Bhalla and supported and protected her from unfair liabilities. The impact for the case are that the judgment changed the game for independent directors and non-executive directors because they gained protection from false cases. And not only that, the executive director and signatories were remained fully accountable. And thirdly, the complaint also spells out the responsibility and roles and liabilities of different directors. And cases like Pooja Ravindra vs. Devsani versus State of Maharashtra also reaffirm the principle of this case. And the balance is simple: protect the innocent and punish who are actually responsible. So that is it for S.M.S. Pharmaceutical versus Neeta Bhalla 2007 case. It clearly shows that title doesn't create liability, the responsibility does.
A lesson that still safeguards directors and strengthens corporate governments in India today.